So in the last class, we were studying about the buyback of shares. We shall be starting from the C point again. The buyback is 25% or less of the aggregate of the paid up capital and free reserves of the company. Means what? That if the buyback amount is less than 25% of the paid up share capital and free reserves of the company, or all the shares and or other securities for buyback are fully paid up. The buyback with respect to listed companies is in accordance with SEBI's regulations. The ratio of the debt owned by the company is not more than twice the share capital and its free reserves after such buyback. Buyback should be completed within a period of 1 year from the date of the closure of the preceding offer of buyback, if any. Every buyback should be completed within the period of 1 year from the date of passing the special resolution or resolution of the board, as the case may be. So what are the provisions? Firstly, only shares and securities which are fully paid up can be buyback can be done with the provision of buyback. Then second, buyback with respect to listed companies is accordance with the in accordance with the regulations prescribed by SEBI. Then the ratio of the debt owned by the company is not more than twice the capital and its free reserves after such buyback. Then buyback should be completed within 1 year from the date of the closure of the preceding offer of buyback, if any. Then next, every buyback should be completed within the period of 1 year from the date of passing the special resolution or resolution of the board, as the case may be. Then the shares or securities bought back should be extinguished and physically destroyed within 7 days of completion of the buyback. The securities cannot be resold. Once the securities which are taken back by the company, they cannot be resold to any other person. Once they are buyback, they shall be completely destroyed within a period of 7 days after such buyback has been completed. Then next we have buyback for whom. A company can buy back its own share securities from the following sources. So what are the sources through which buyback of the company can be done? Now, firstly, the existing security holders, or on a proper proportionate basis, or the open market, maybe through book building process or stock exchange. Then employees to whom securities were issued pursuant to a scheme of stock option or sweat equity. So these are the uh, three sources through which company can buy back its own shares and securities. Then next we have notice of the meeting. The notice of a meeting at which special resolution is proposed to be passed shall be accompanied by an exclamatory statement stating a full and complete disclosure of material facts, the necessity for buyback, the class of security intended to be purchased under the buyback, the amount to be invested under the buyback, the time limit for completion of buyback. So what is the notice of meeting? Firstly, a special resolution is to be passed for the accompanied with the explanatory statement stating a full complete disclosure of the material facts. Whatever material facts are required shall be disclosed. Then necessity. What is the necessary? Why is it so necessary to buy back the shares? Then class or securities which the company is intending to buy back. Then the amount invested under the buyback and the time limit for the completion of the buyback. So these are the things which shall be mentioned while sending the notice of the meeting to every shareholder and the board of directors. Then filing of the declaration of solvency. After the special resolution has been passed authorizing the buyback, a declaration of solvency in the prescribed form verified by an affidavit signed by two directors, one of whom shall be the managing director, must be filed with the registrar of company and SEBI by a company which is listed in a recognized stock exchange. The declaration of solvency is not required to be filed by any unlisted company. Now, filing of declaration of solvency means what? That after the buyback resolution has been passed in the meeting, then after that A declaration of the solvency is in a prescribed form. Then next, verified affidavit signed by two directors, of which one shall be the managing director, means the director who is managing and who is into the business every day. Then must be filed with the register of companies and SEBI by a listed company in a recognized stock exchange. The declaration of solvency is not required to be filed by a unlisted company. Next, we have restriction on further issue of securities. After the buyback is complete, a company shall not make further issue of securities within a period of 6 months. However, it may issue bonus shares. It may also discharge its subsisting obligations such as conversion of preference shares or debentures into equity shares. So, restriction on further issue of securities. Once the buyback is done, then a company shall not issue further securities or new securities for a period of 6 months. However, it may issue bonus shares and also discharge its subsisting obligations such as conversion of preference shares or debentures into equity shares. This also can be done by but no further new issue of securities can be done. Then next we have maintenance of record. The company should maintain a register for recording the details of securities bought back, the consideration paid for the securities bought back, the date of cancellation of securities, the date of exchanging and physically destroying of securities, and such other particulars as may be prescribed. So maintenance of record. A record has to be maintained about what securities has been bought back by the company, then the date of cancellation of those securities, and the date of extinguishing and physically destroying of securities, such are the particulars as may be prescribed. So these all things shall be maintained by the company in order to have a proper record of the buyback. Then next we have filing of a return for buyback. After completing the process of the buyback, the company has to file a return with SEBI and the registrar. The return must contain the prescribed particulars and it is required to be filed within 30 days from the date of such completion. However, no returns are required to be filed with the SEBI by a company whose shares are not listed on any recognized stock exchange. So, penalty for return. Next, we have filing of a return for buyback. The if after completing the process of buyback, if the company has to file with SEBI and register the return, and it must contain the prescribed particulars and it is required to be filed within 30 days from the date of such completion. However, no returns are required to be filed with the SEBI by a company whose shares are not listed on any recognized stock exchange. Next, we have penalty. In case the company is into default, in that case the company and the officers liable shall be punishable with the following things. If a company makes a default in complying with section 68 or any rules made thereunder, the company who is in default shall be punishable with fine ranging from rupees 1 lakh to 3 lakh, and for every officer of the company who is in default shall be punishable with imprisonment up to 3 years or with fine ranging from rupees 1 lakh to rupees 3 lakhs or with both. So this is the penalty for the officer as well as the officer and the company in default. Next, we have transfer of money to capital redemption reserve account. Where a company purchases its own shares out of free reserves, then a sum of total nominal value of the shares purchased must be transferred to the capital redemption reserve account, and the details regarding such transfer must be disclosed in the balance sheet. So transfer of money to capital redemption reserve account shall be done, and purchases its own shares out of free reserves, then the sum equal to the nominal value of the shares purchased must be transferred to the capital redemption reserve account, and the details regarding such shall be disclosed in the balance sheet. Next, prohibition for buyback in certain circumstances. In certain circumstances, the company shall not be allowed for buyback. And what are the different provisions for not having the power to buy back are: the power of a company to buy back has been curtailed by the following provisions. No company shall directly or indirectly purchase its own shares or other specified securities. though through any subsidiary company, including its own subsidiary companies, or through any investment company or group of investment companies. So firstly, directly or indirectly, no company shall purchase their own shares. That is, any company who is a subsidiary company, including its own subsidiary company, or through any investment company or group of investment companies. Then when the company is in default in payment of deposit, redemption of debentures or preference shares, or repayment of a term loan of any financial institution or bank, no company is permitted to purchase its own shares directly or indirectly if the company has not complied with the provisions of Sections 92 Annual Return, Section 127 Default in Paying Declared Dividends, and Section 129, 123 Filing of Annual Report or Accounts. Besides these regulations, SEBI has also issued regulations, namely SEBI Buyback of Securities Regulations 1998 in this regard. Next, we have allotment of shares and securities, section 39, meaning according a company issues a prospectus and thereby invites the public to subscribe to the shares of the company. This is just an invitation when a prospective shareholder makes an application to the company to take its shares. It is an offer. When such an application is accepted, it is an allotment. It is an acceptance by the company for of the offer of the prospective shareholders to take shares. This acceptance of an offer creates a binding contract between the company and the allottee of shares. So, what do you mean by allotment of shares and securities? Means a prospectus is given to the members or to the public in general. The prospectus holds an invitation through which company invites different people or different public to take application and to become the member of the company. Once acceptance has been shown or an acceptance offer has been given to the public, then in that case he or she is allotted the shares, whatever number of shares are held by them. This is called the process of allotment. In fact, the term allotment has not been defined in Companies Act. However, in some court cases, this term has been explained as follows. According to the Supreme Court ruling, allotment is the appropriation out of the previously unapproached capital of the company of a certain number of shares to a person. Till such allotment, the shares do not exist. It is on allotment that shares come into existence. Sri Gopal Ulan and Company versus Calcutta Stock Exchange Association, AIR 1964 SC 250. In this case, this was the ruling held by the Supreme Court. Allotment is an appropriation by the board of directors of a certain number of shares to a particular person in response to his application, represented by lawful guardians. Devan Singh versus Menvara Films Limited, Air 1959, Punjab 106. These were the two cases in which the court held allotment of shares. And next we have general principles relating to allotment of shares. As discussed earlier, an allotment of shares results in a binding contract between the company and the allottee of shares. Hence, for the allotment provisions of Companies Act as well as the provisions of the Contract Act are applicable. So, for the purpose of allotment, remember Companies Act as well as the Contract Act. These two acts are generally applicable. The general principles with regard an allotment of shares are as follows. Firstly, proper authority. The allotment is to be made by proper authority. The power to allot shares has been vested with the board of directors, but the board of directors can delegate this authority to the allotment committee. An allotment committee made with proper authority will be made without proper authority will be invalid. So firstly, the board of directors are given power. They shall form a allotment committee, and the allotment committee shall prepare proper and valid allotments by having a proper procedure for allotment. Next, within reasonable time. Once the application has been received for allotment by the company, the allotment must be made within a reasonable time. If there is unreasonable delay in the allotment, the application lapses. What is reasonable time is the fact of question. In some cases, 3 to 4 months time is considered as a reasonable time. So, within reasonable time means within a period of 3 to 4 months, this process shall be completed and it shall be considered as a reasonable time by the Companies Act for the companies. Next, we have allotment to be communicated. The allotment must be communicated to the applicant. It is like any other contract in the process of formation of a contract. It is necessary that the acceptance must be communicated by the offeree to the offerer. It was held by the court that if the letter of allotment is properly addressed, stamped, and posted, it is considered as sufficient communication even if the letter is delayed or lost in transit. So, allotment must be communicated. Proper allotment, it is very important for the company to convey or to communicate the allotment of shares with the members or with the public, because it is a way of showing that the company has allotted some shares to you and the company has taken an action against the money and the forms which you have filled. So it is very important that allotment must be communicated with the shareholders. The allotment must be absolute and unconditional. That means it must be made on the same terms as stated in the application. In other words, a company while making allotment cannot put any other conditions. So the conditions and of allotment must be absolute and unconditional. Revocation of an offer. An application for shares can be revoked any time before acceptance is communicated. However, if any of the above general provision is not complied with, the allotment will be null and void. So, revocation of an offer shall be can be revoked anytime before the acceptance is communicated. Once the acceptance is communicated, then it shall be void. Then next we have statutory provisions. Under the heading of general principles mentioned herein above, we have discussed the provisions of law of contract as it is applicable to allotment. Following are the provisions of the Companies Act as applicable to the allotment of shares, and they are required to be complied with. In case of private companies, the Act does not provide for any restriction as to the allotment of shares or debentures, but for a public company which offers shares to the public for subscriptions for the first time, the following provisions should be followed. Firstly, minimum subscription. A company cannot make any allotment of securities unless the amount stated in the prospectus as the minimum amount has been subscribed and the sum payable on application for such amount has been paid to and received by the company by check or other instrument. So minimum subscription, whatever is the minimum amount of subscription which is stated by the prospectus shall be sent by the public to the company. Once the application is sent with the amount of check and the instrument has been sent, after that the company does not have the right to revoke or to cancel the subscription. This minimum subscription stated in the prospectus must be received within 30 days of the issue of prospectus. If it is not received within this stipulated time, then all money received from the applicant should be refunded to the applicant within the prescribed time. In accordance with SEBI guidelines, a company making a right or a public issue of shares or debentures must receive receive a public subscription within 6 days of the closing of the issue. If it does not happen, then the entire application money must be refunded to the applicants within 15 days of the money becoming due. Otherwise, it will have to be paid along with 12% interest. So these are some of the provisions regarding the allotment which the company has to follow, and also the applicant has to follow it while applying for the shares in the company. Application money. The amount payable on application on each security shall not be less than 5% of the nominal value of the security, or such other percentage or amount as may be specified by the SEBI by making a regulation in this behalf. So what does this mean? That not less than 5% of the nominal value of the shares shall be given to the company, and it shall be specified by SEBI in the regulations that this much amount shall be compulsorily received by the company from people. Then the time limit to keep the subscription list open. As per SEBI's guidelines 2000, the subscription list for public issue should be kept open for at least 3 working days and not more than 10 days. In case of an infrastructure company, the maximum period is 21 working days. In case of rights issue, this list shall remain open for at least 30 days and not more than 60 days. The validity of an allotment is not affected by any contravention of the above mentioned provisions relating to the opening of the subscription list. But in the event of any such contravention, the company and every officer of the company shall be punishable with fine up to rupees 50,000. So the time limit for subscription is open shall be minimum for 3 days and not more than 10 working days. In this case of an infrastructure company, the maximum period is 21 working days, and rights issue, this list shall remain open for at least 30 days and not more than 60 days. The validity of the allotment shall be affected in case any contravention of the above mentioned provisions is done, and in case there is any contravention on the part of the company and officer, in that case they shall be punishable with fine up to rupees 50,000 or whatever has been stated by SEBI. Listing of security on a stock exchange. Shares or debentures or other security which are to be sold at the stock exchanges must be listed on them, and for listing of such shares or debentures, prior permission of such stock exchange is necessary. Permission for listing. Every company intending to offer shares to the public for subscription by the issue of prospectus has to make an application to one or more recognized stock exchanges for permission for listing of its shares. It is necessary to state in the prospectus the name of the stock exchange or each of the stock exchange. So in case of listing, every company which is dealing or which is selling shares or debentures, it must list itself with the stock exchange, and for this purpose, firstly the provision is permission for listing. Every company intending to offer shares to the public for subscription by the issue of prospectus has to make an application to one or more recognized stock exchanges for permission for listing on stock exchange. Then next we have money to be returned to unsuccessful applicant. Where the permission for listing has not been applied for or such permission has not been granted by the stock exchange, the company shall forthwith repay without interest all monies received from applicant. If such money is not repaid within 15 days after the company becomes liable to repay it, the company and every director of the company who is an officer in default shall jointly and severally be liable to repay the application money to the prescribed interest, that is minimum 4% and maximum 15%. So these are the penalties which are there for in case the company does not repay to the applicant, in case the company has rejected some of the applicants, in case there is oversubscription in the company, or in case the public or in case the people have failed to file the record or filed the form, and details are incomplete, or such anything has happened. In that case, this shall be done by the company compulsory. Next, we have basis of allotment. When a public offer is made, so far as response of the public is concerned, three possibilities are there. The amount subscribed for by the public may be less than 90% of the issue size. In such circumstances, money is required to be refunded. If there are no underwriters for the issue, otherwise allotment will be made to public as well as underwriters. So in case they when offer is made to the public, and in that case the amount subscribed by the public may be less than 90% of the issue size. In those circumstances, money is required to be refunded if there are no underwriters for the issue. Then next we have the amount subscribed may be equal to the issue size. Here the allotment will be according to the number of shares applied for. Then the amount subscribed for may exceed the size of the issue. In such a case, the board has to take decision on allotment so as to ensure fair and just allotment to applicants. This situation is called oversubscription. All money in excess of the application money on shares allotted must be repaid forthwith without interest. In case of unlisted shares, the basis of allotment may be as under. Firstly, lottery method. Secondly, pro rata method, that is allotment in proportion to the number applied for. C. Preferential treatment to small applicants. It is to be noted that SEBI guidelines stipulate a minimum reservation of 50% of the net offer of securities to be allotted to small individual applicants who have applied up to uh, 10 markable 10 markable lots. So this is about the subscription. And now next is irregular allotment, which we shall be seeing in the next class.